Welcome to Literary and Jury Charge Practice. Ready? Here we go. An inhabited dwelling is a structure which is occupied and customarily used as a dwelling place. If you are satisfied beyond a reasonable doubt and agree unanimously that the defendant made an entry with a specific intent to steal or to commit a felony, you should find the defendant guilty. You are not required to agree as to which particular crime the defendant intended to commit when he entered. In the crime charged in count 1, there must exist a union or joint operation of act or conduct and a certain specific intent in the mind of the perpetrator. Unless such specific intent existed, the crime to which it relates is not committed. The specific intent required is included in the definition of the crime set forth, as I just read that definition to you. The specific intent with which an act is done may be shown by the circumstances surrounding the commission of the act. However, you may not find the defendant guilty of the crime charged unless the proved circumstances are not only consistent with the theory that the defendant had the required specific intent, but it cannot be reconciled with any other rational conclusion. Let's try some literary material. And the subject or the title of this literary is Visually Certified. Ready? Do you get nervous when you walk into a room of strangers and clients stare at you as if trying to predict if you're good at what you do? Does it stress you out having attorneys judge your competence simply based on first impressions? At one point, I thought attaining my NCRA certifications would change these judgmental looks, that having letters behind my name would define my skills as a competent reporter. I thought entering a room would feel different. I thought there would be some drastic change in how I would feel when engaging a client for the first time. But the truth is, despite how valued those certifications are within the court reporting community, those outside it rarely understand their meaning well enough to understand their significance. Because our clients don't have any other point of reference, they tend to draw their conclusions about our professional capabilities from how we present ourselves. So how do we control how we're viewed? Walking in a room and saying I'm a court reporter doesn't automatically command the same respect as saying I'm a president, judge, or CEO. In fact, it seems to be the exact opposite. When I walk into a room, clients don't automatically respect me. I'm merely seen as a girl who can type really fast. Ever seen someone mimic typing gestures to define what we do? And I'm tired of the repeated cycle of trying to educate the outside world that we're not going to be replaced by digital recorders, and that it takes more than a couple brain cells to do what we do. So if we're going to be judged by initial appearances, then let's control how we're judged. Let's look the part of a highly certified reporter. In other words, let's be visually certified. The first thing people see is our attire. Make it a point to wear attire that reflects your position as a professional reporter, regardless of your clientele. It doesn't have to be complicated. A basic suit can command a lot of respect. And by basic, I'm not talking about boring and cookie cutter, but a nice suit with a subtle style. Simply looking professional will ward off that initial judgment. Secondly, our equipment is an extension of us. It represents the manner in which we will handle transcripts, exhibits, or a CART session. Having an up-to-date steno writer and laptop with the screens wiped clean of fingerprints, fur, and crumbs represent that we keep our professional and personal lives separate. And don't forget cables, making sure they're not a tangled mess, but folded nicely with Velcro straps provides a subtle message that we are organized and efficient. And what's better than Velcro straps wrapped around cables? The absence of cables providing iPads and wireless connections shows you have the ability to troubleshoot your real-time systems and gives the appearance of an advanced and educated reporter, captioner. Also, we have the advantage of sitting at the head of the table, which allows us to be in control of the room and project competence and professionalism. Nonverbal cues help guide clients' opinions and inform them about how they should interact with us. Instead of slouching in our chairs and hunching over our computers, sit with purpose. Our posture will help decide how much merit we have in the room. So by looks alone, we have gained visual certifications and we haven't even started writing our job yet. That's when we hit them with the next layer of certifications. By that I mean be the Mary Poppins of the room. It's amazing how providing a few extras, maybe personalized clips or pads or pins to help them do their job, can gain respect. And to update the Mary Poppins effect, be virtual. In other words, be the Google of the room. Be able to inform your clients of the nearest and most popular restaurants, where to catch the train or taxi, and the best way to the airport or hotel. The ability to save them a few minutes by gaining knowledge from the locals helps make us invaluable to their experience. So take control of those judgmental looks and be the respected, highly certified reporter captioner you are. Take ownership of our diplomatic role as independent officers of the court. Show off your real-time streams, because we can all be certified real-time reporters. The reality is we are in a profession where we will continually be judged on our looks. So look the part and play the role. Let them judge us on our looks, because our actions and appearances can earn for us the respect we deserve, because sometimes actions speak louder than words. Let's get back to a medical report that we had started. Ready? Here we go. Examination of the head revealed it to be symmetrical and with no irregularities noted. The hair was dark brown in color and the scalp was clean. Examination of the neck revealed very shoddy lymphadenopathy anteriorly and posteriorly. No other masses were palpable. The thyroid was non-palpable. Examination of the chest did not reveal any bony abnormalities. The respiratory excursions were equal bilaterally. Examination of the lungs revealed them to be clear in osculation and percussion. The heart PMI was noted to be in the 5th intercostal space at the mid-clavicular line. The apex beat was noted to be 96 per minute and equal to the radial beat. No thrills or murmurs were noted. M1 was noted to be greater than M3 and P3 greater than A2. Examination of the abdomen revealed it to be slightly scaphoid. There was no masses noted or any tenderness noted on examination. The liver, kidney, and spleen were non-palpable. There were normal bowel tones noted. The examination of the rectum and genitalia was deferred. Examination of the extremities revealed them to be freely movable without any clubbing, cyanosis, or edema noted. The skin, other than the scarring noted above the left eye, was essentially non-revealing. The neurologist examination revealed the cranial nerves all to be grossly intact. There were no pathological signs noted, nor any muscle weaknesses noted. The deep tendon reflexes were equal bilaterally. The biceps, triceps, and brachioradials were graded 2+ equal and physiological. The examination of the lower extremities, the deep tendon, knee, and ankle jerks were graded to be 2+ equal and physiological. The examination of the back did not reveal any bony abnormalities, no spine or CVA tenderness. The positive findings on this examination were limited essentially to the small area of scarring immediately beneath the left eyebrow, which measured approximately 2 centimeters in length and approximately 2 millimeters in width. The impression at this time is a normal physical examination without any permanent residual fibrosis or scarring and without any involvement of any cranial nerves or any gross involvement of the vision of the left eye. Ready? Here we go. He indicated he could not figure out why the testimony differed in the two portions of the transcript. He indicated that he thought that the court reporter could have been in error. It could have been that he had not read the report well enough. He indicated that he was required to work additional hours at that time, giving that as the reason why he didn't have time to read all of the testimony. He indicated that he didn't know why the testimony differed. He asked if he could have some time to look at the statements that he was supposed to have made. The attorney let him look at the transcript in court. The police officer's lack of credibility was so noted by the court. The police officer's lack of credibility was a problem. He indicated that the police officer was responsible for the testimony that did not match. At one point during the trial, the defendant's attorney asked for a directed verdict based upon the fact that the evidence in the case did not seem to point to the defendant's guilt. The fact that the police officer had conflicting testimony in both his own verbatim transcript and in his testimony in court was reason enough for the defendant's attorney to ask for a directed verdict. He indicated that the police officer did not provide a credible transcript. The case was supposed to be based upon the testimony of the police officer. If there were errors in the transcript as claimed by the police officer, those errors should have been found prior to the police officer signing the transcript. He was responsible for reading and signing the record. Any police officer should know that it is his duty to find any errors of fact that were made in the testimony and that he should not have signed the prior testimony until such errors in the verbatim transcript were noted. Any police officer should know that it is important to provide a consistent testimony. The police officer used an excuse saying that he did not have enough time to review the verbatim transcript. It was pointed out to him that he had the amount of time that everyone was given under the law to review the testimony. All right, this literary is called In Your Own Words, Reporting the Coroner's Inquest. Ready? The typical scene of an inquest begins with the gallery abuzz with energy as news reporters and members of the public find empty seats. Videographers and photographers line the walls. The decedent's family members and attorneys enter the room, sitting front row center. Law enforcement officers begin filling the remaining empty chairs and benches. The prosecutors make their appearance, and the coroner welcomes the small 7-man jury that has just been escorted into the room by a court bailiff. A large flat-screen television sits just to the right and slightly behind me, ready to display evidence recorded of the death of the individual. My steno machine and laptop sit in the front of the courtroom, ready for the coroner's inquest to begin. Just as we are ready to start, my nerves fire and my heart races with anticipation of the first words to be spoken for the day. as the words usually come rapid fire until the proceeding settles into its own pace. My fingers feel like sticks, just as they did in school when I knew I was about to pass a speed test. For some reason, those first few words of an inquest are the hardest. Then I breathe and try to relax. I remind myself I am preserving testimony no different than any other day of reporting. It's my responsibilities of the day that are somewhat different than an average day in court. There is no judge to help maintain order in the courtroom, with a room packed full of onlookers, jury members, the prosecutors, and coroner. Not only do I have many people to keep track of and identify, but there are also multiple people I need to control if things get out of hand. I equate the coroner's inquest to a combination of a trial, deposition, and public hearing. The coroner's inquests of Montana are an unusual public proceeding. Inquests are an examination into the cause and manner of death of an individual, and they are utilized to help determine whether that death was caused by criminal means. Unlike a trial, where someone has already been charged with taking the life of another individual, an inquest can be utilized in essence as a public advisory opinion as to whether criminal charges should be filed. Coroner's inquests are often conducted when a death is unattended or caused by another, and they are required when someone dies in the custody of a police officer, even if the cause of death is by natural means. Ultimately, the decision to file charges remains with the prosecutor. Jack Healy authored A More Public Opinion for Investigating Shootings by Police Officers, which was published in the New York Times on March 17, 2015, just days after the conclusion of an inquest I reported related to an officer-involved shooting in Missoula. The coroner's inquest referenced in Healy's article was conducted at a time when much of the nation was in an uproar over another officer-involved shooting that occurred across the country. In his article, Healy characterized the coroner's inquests of Montana as an old-time process that was more prevalent during the times of Wyatt Earp and Doc Holliday. That reference in reality is not far from the truth, at least here in Montana. For example, in 1893, a coroner's inquest was held for the officer-involved shooting of a man named Samuel Sam Shermer. Detective Chris Shermer with the City of Missoula Police Department is the descendant nephew of Sam Shermer. Recently, Detective Shermer shared with me his collection of documents and articles related to Sam Shermer's crime, capture, and death. In 1893, Sam Shermer plotted with Jack White, Jack Chipman, and Charlie Jones to engage in a train robbery. On August 26, 1893, the group of outlaws successfully robbed a train of the Great Northern Railroad outside of Grey Cliff in south-central Montana. They escaped capture and fled towards the Blackfeet Indian Reservation in northwestern Montana. The group made off with approximately $5,000 worth of loot. Estimated value today would be $136,000. It is believed they may have stashed a portion of the stolen items somewhere along their escape route. On October 4, 1893, Shermer, Chipman, Jones, and a man named Jimmy Moots, who replaced White along the escape, were located by U.S. Marshal Samuel Jackson in an area now considered part of Glacier National Park. There, a shootout with law enforcement ensued. Chipman was killed instantly, Moots received a superficial wound, and Jones escaped and was later killed in an unrelated incident. Shermer was shot in the hip, captured, and taken to jail in Demersville, Montana, a railroad boomtown of 1,000 people with 100 saloons and drinking establishments. Shermer died in custody on October 8, 1893, and was subsequently buried at the Demersville Cemetery in an unmarked grave. We will get back to this one. Ready? Here we go. In this case, the attorneys worked to defend the defendant from a charge of murder, the evidence to indicate that the subject had committed the crime. If convicted, the suspect might be subjected to the death penalty. The evidence was presented and the suspect was charged with the crime. In preparing for the initial appearance, the attorneys tried to present as much evidence as they could to support their sides. As this crime might result in the death penalty, the judge issued a gag order to keep both sides from discussing the case. There was a question as to whether there was an improper use of wiretaps. Wiretaps are not legal in this state. If there was an illegal use of wiretaps, the case would be questioned. At the initial appearance, the suspect was asked what plea he would make. He indicated that he was not guilty. His attorney also requested that he be granted a change of venue. That means that the attorney was not happy with the location in which the trial would take place. At the hearing, the judge heard arguments concerning wiretaps placed on the defendant's phone. The fact that wiretaps were not legal was important to the case. The judge granted the change of venue in the case. Granting a change of venue resulted in the trial taking place in another location. The defendant's attorney was happy with the change in venue. If the defendant was convicted in this venue, the attorney felt that he would not receive the death penalty. At this point, that was the matter to him. He did not want to have his client be subjected to the death penalty. There was probably cause to normally charge the suspect with the crime. The probable cause included fingerprints. That probable cause was explained away by the defendant. The suspect was formally charged with the crime. His attorney questioned whether he had been properly Mirandized, but it was determined that he had been properly Mirandized in this case. The defendant's attorney worked at the preliminary hearing where it was necessary to determine whether there was enough evidence to bind over the suspect for trial. The judge determined that there was enough evidence. At the preliminary hearing, it was determined that there was enough evidence to bind over the suspect for trial because of the amount of evidence available. If convicted, the judge told the suspect that he could face the death penalty. A judge must only find that there is a reasonable cause to believe the defendant committed the crime. The judge in this case found that there was enough reasonable cause to believe that the defendant committed the crime and bound him over for trial. The defendant did admit to knowing the victim and spending time outside of work with her. He did not admit to anything else. He admitted to talking to the victim and to having met her for lunch on occasion. He admitted to having lunch with her on the day that she was murdered. He did not admit to sending the victim messages that referred to murder. And that will conclude our literary and jury charge practice.